All right, let's talk about something we all see every single day, but almost none of us ever really understand. I'm talking about the fine print. Come on, be honest, you've done it, right? We all have. That new app, that software update. You just see that little box, you click it, and you move on with your life. But have you ever stopped to wonder, what on earth are we actually agreeing to? Well, that little I agree moment, it's so common it actually has a legal name. And once you understand it, it kind of pulls back the curtain on this huge power imbalance that's just baked into our modern lives. So what you're clicking on is something called a standard form contract. And it's exactly what it sounds like. It's an agreement that's been drafted completely by one side, usually some big company. There's no haggling, no back and forth. It's just a preset deal. But these contracts have other names that are way more revealing. I mean, take it or leave it contract. That pretty much says it all, doesn't it? Or how about adhesion contract? That's a fancy way of saying you're just stuck with it. You're forced to adhere to terms someone else wrote. No matter what you call it, they all point to the exact same thing, this massive power imbalance. So, you might be asking, why do we even have these things? Why are they allowed? Well, it really boils down to this classic tug of war, right? It's a battle between what's efficient for business and what's fair for you. Look, from a business perspective, this system is an absolute lifesaver. I mean, can you even imagine an airline trying to negotiate the terms of every single ticket they sell? It would be total chaos, right? Impossible. So these contracts, they let millions of transactions happen super smoothly. But for us, the consumer, well, that's a whole different story. We have literally zero power to negotiate, and there's always that risk that some really unfair clause is just lurking, buried deep in that wall of text. Okay, but here's the really important part. Just because a company slaps something into a contract doesn't automatically make it the law of the land. Nope. Even these super one-sided deals can go too far. They can cross a line, and when that happens, the legal system can and does step in. Because even the law has a breaking point. And that is the million-dollar question that courts have to wrestle with all the time. Where is that line? At what point does something go from just being a bad deal to being a truly unjust deal, something the legal system just refuses to enforce? This quote from a huge case in India's Supreme Court absolutely nails it. It cuts right to the core of the whole problem. The court just came out and said it. In these dotted line contracts, there is no meaningful choice. It's an illusion. And because of that, the legal system has a duty to step in and shield the weaker person from terms that are just flat out unjust. And there's a legal word for this breaking point. It's called unconscionability. It's a big word, but the idea is simple. We're not just talking about a contract that's a little bit unfavorable. No, this is for a clause that is so ridiculously oppressive, so shockingly one-sided that it literally shocks the conscience of the court. It's a deal so bad that a judge looks at it and says, no way, I can't enforce this. So here's the takeaway. You're not totally powerless in this situation. Not at all. Over hundreds of years, the law has actually developed some really clever tools. You can think of them like legal shields, designed specifically to protect people like us from the absolute worst parts of these contracts. And to do that, courts have this kind of toolkit with 4 main principles inside. These are principles that have been built up over centuries to try and balance the scales. So let's crack open this toolkit, right? Think of these as your hidden legal protections. Let's go through them one by one. Okay, first up, reasonable notice. This one's pretty intuitive. A company can't legally bind you to terms that they've hidden away somewhere or that you never really had a fair chance to see. It's on them. They have a duty to actually bring those conditions to your attention. And there's a great classic case that really set the stage for this. Picture this. It's 1875. A guy buys a ticket for a steamer ship. The trip goes wrong, his luggage gets lost. He goes to the company, and they just point to this tiny clause on the back of his ticket that says, sorry, not our problem. Well, the court, which was the highest court in Britain, the House of Lords, they were not having it. They disagreed, big time. Their ruling was just beautifully simple. Because there was nothing on the front of the ticket that even hinted at the conditions on the back, the passenger couldn't be bound by them. It's as simple as that. No reasonable notice, no contract. You see how clean that logic is? It's just so simple. If the company really wanted that clause to be part of the deal, they had to do their job and take reasonable steps to let them know it was there. Just hiding it on the back? Nope, not good enough.
All right, our second legal shield kind of builds on this. It's called contemporaneous notice. It sounds fancy, but it all comes down to one thing: timing. Timing is everything. The company has to tell you about the terms before or at the exact moment you make the contract, not 1 second later.
And this classic hotel room example makes it crystal clear. So, a couple checks into a hotel, they pay at the front desk. Boom, that's the contract, right there. Then they go up to their room, and they see a sign on the wall saying, "We're not responsible for stolen items." Well, guess what? Too late. The contract was already made downstairs. So when their stuff gets stolen, that sign means nothing. The hotel is still on the hook. Okay, shield number 3 is a really powerful one. It's called fundamental breach. And the idea here is that you can't hide behind the fine print to excuse a complete, total, absolute failure to deliver on the most basic promise of the deal. Think about it like this. You buy a car. What's the fundamental purpose of a car? It's to drive, right? So if the engine literally explodes a week after you buy it, the seller can't just shrug and point to some as-is clause buried in the paperwork. That's a fundamental breach. They failed to deliver a car. And finally, our fourth protection. This one has a cool Latin name, contra proferentem. All it means is against the one who offers. It's a simple but brilliant idea. If a term in a contract is confusing or vague or could mean two different things, well, the court will interpret it against the person who wrote it. I like to call this the "you wrote it, you're stuck with it" rule. Basically, the law says to the big company, hey, you're the one with all the lawyers, you wrote this thing, so the burden is on you to be crystal clear. If they write something confusing, they're the ones who have to deal with the consequences. So look, at the end of the day, these standard contracts are just a part of modern life. We're not getting rid of them, but they are not a blank check for companies to just write in whatever they want. The law has these safeguards, these shields built right in to make sure there's at least a measure of fairness. Hopefully, you'll be thinking that your click isn't necessarily the final word, that there are these powerful old legal principles out there designed to protect you from being taken advantage of by that fine print. And just knowing that, well, that's real power right there.